Hello and welcome to the News Minute. A local court in Bengaluru had given gag orders against the media, which is reporting on the Dharmasthala case, and it has also ordered pulling down of close to 9,000 links, particularly on the Dharmasthala coverage. To talk about this, I have with me Justice Chandru, the retired judge of the Madras High Court. Before I go across to him, here is a quick reminder. We have been closely following the Dharmasthala case and my colleague Shivani Kawa is relentlessly reporting from ground zero, bringing you all the updates that is taking place in that region. And we have also interviewed experts, we have interviewed advocates. My colleague Pooja Prasanna went to Dharmasthala to do a show called Let Me Explain. So if you want us to continue doing what we are doing, do become a paid subscriber of the News Minute and support independent journalism. So thank you so much for talking to us. In the past 10 years, the local court has given many ex parte orders, against the media. What do you have to say about this trend, sir?
Now, I also saw that in the last few years, Bangalore City Civil Court, orders are being obtained on prayer restraint on the reporting or withdrawal of news from the social media, all that is there. The prayer restraint concept was never part of the any statutory legal system. If a person whose reputation is damaged or an institution who has been defamed, they have mechanism under the civil law to ask for damages. When there is a damage is a remedy for a civil wrong, it is also made part of a criminal prosecution under Section 499 CRPC, now Bharatiya Nagarik Suraksha Sangeeta. Now, in those criminal defamation, one has to prove how they were defamed. So, you will have to make an allegation, you will have to prove. Now, in case of prayer restraint, neither the judge nor the person who are affected, in these cases, the large people who have a right to access to information, and the media which has a right to report on all public matters, they are affected. Now, this system of granting injunction, prayer injunction, arises only in case of civil wrong, and reputation, it can always be compensated by damages. Now, you can't say, don't damage my reputation. Now, how do you gauge this issue? But then I found in the Bangalore City Civil Court, there are more than 150 gag order. You call it gag order, we call prayer. Now, Supreme Court recently given a guideline that in case of criminal proceeding, it should not result in unfair trial for the accused. The magistrate or the session judge can direct postponement of publication, not restrain, postponement. That is for the fair trial of the accused who is facing trial. So, a fair trial is part of a constitutional right, not a prayer restraint. Now, prayer restraint available in injunction specific relief act, but then that is given only in case of properties, not on reputation issue, because damage is remedy. Now, by giving prayer restraint, you are effectively managing. Now, in the last Dharmasthala case, they even asked for withdrawal of the use, which is called John Doe suit. In America, it was evolved. John Doe means you do not know the names of defendants. In India, it's called Ashok Kumar. That is, unnamed defendants are mentioned as Ashok Kumar. Now, in Bangalore, they mention as John Doe, like in America. You can get injunction against unnamed people. That is very extraordinary. The extraordinary situation where you may get that an order, but not as a matter of right that you get this kind of order.
But this is something which is very usual, is what we are told. Like when we talk to advocates,
it is usual. Anybody who record has never been informed by higher court saying you can't do this. For example, Jayalalitha tried the same thing against Nakir and Gopal, that he cannot publish. But the Supreme Court said Supreme Court order is final. That Nakir and Rajagopal versus Jayalalitha, they've clearly said there is no question of gagging, no question of restraining. Later on, judges evolved. The reputation of a person is affected. He may be heard. But in this case, what reputation? They are going to investigate the matter. The investigation comes because there is somebody who is a whistleblower. Now, very rarely whistleblowers come out to speak on a mass crime. In public interest, you must encourage the investigation rather than stopping any kind of news on that. It may be a bigger but it may be a reputed, but that's not the issue. Issue is the allegations are so severe, the public have every right to know the happenings.
The question is here ex parte, sir. Deciding ex parte.
Nityananda asked for a restraint order in my court that no interview should be there. I dismissed it. There are several people. Mr. A. Raja of the DMK, he was a central minister. He asked against a restraint against newspaper. We said no. That is not the ethos. That's not the law of this land. That's what we have said. I think some of these cases must go to higher courts so that better results will come.
The higher courts have also, warned in the past that the such orders should not trample upon the freedom of speech and expression. The Telangana High Court had warned, but despite that, we keep seeing these ex parte injections. Why is the other side not being asked?
We should know this is only an ex parte order. The court can always interfere, but the point is the damages cannot be compensated. For example, 8,004 URL spaces you withdraw mean you are completely erasing every kind of and in the advancement of information technology, people can have a screen saving. People can always take a photocopy and circulate. You can never hide something from a public because the technology has completely opened the floodgates of information revolution. Now, this order of a restraint order, I think if it goes to the higher court, they may pull them up and the Bangalore judges will have to be go through certain orientation on what to do and what. We have a judicial academy at the state level and the national level. We do train, we do interact with the judges. We do have orientation on information technology, on the restraint orders, on freedom of speech. We do that. But then how many learn from all this? That's another question.
Somebody who is very powerful goes to court when there is an active investigation going on about a very serious issue. Like you said, there is a whistleblower who has come out and who has made startling allegations, and obviously the media will report. Now there is an order like this all of a sudden saying 9,000 links should be pulled down. What do we make of these orders?
The problem is very simple. The judges must have certain basic values of liberty, right to expression, constitutional right, all that. And then they are supposed to uphold those rights. Now when Jayalalitha was in power, Nakiran Gopal could not do anything, but it is the Supreme Court which interfered. Similar thing happened the other way around. When Vasanthi, a Tamil writer, wrote a biography on Jayalalitha, the only mistake she did was she gave an interview, pre-publication interview to Outlook. Basing that, Jayalalitha filed a case and stopped the press. The stay order continued, and then the publisher has to withdraw the books from bookstall, and the shelf time is only 3 years. After the books are all destroyed, but the case is still not over. Now the problem is people who have a right to know. Jayalalitha is now gone. What happened to the case, we do not know. What I'm saying is, when there is an irreparable injury which cannot be remedied by any action, then only such orders can be given. There is no irreparable injury if somebody's reputation is lost. They can always claim damages. Today there are many ministers who file crore rupees suit, 1 crore, their worth is 1 crore. There are some people do test case, 1 rupee case also has been filed. That's all right. I am only saying, so long as the civil law provides for damages of the reputation, no question of any prior restraint order. And you cannot gauge a press, you cannot gauge a writing in the admission stage and then they'll stop it. That means you are doing irreparable damages, not remedying injury.
And such blankets order, ex parte orders, can it be termed illegal if it goes to higher court?
No, it is not acceptable in Indian judicial system. That's why I'm saying my own judgments are there. There are Supreme Court judgments. And then it only shows that they are defying and following those orders.
It's in defiance. The orders are in defiance.
It's in defiance of the established order. Under Article 141, the law declared by the Supreme Court is the law of the land. And if you don't follow, That means you are violating the Supreme Court order.
Right, sir. Thank you so much for talking to us.